Next case on the docket is R.W. versus the Department of Children and Families.
Good morning, Your Honor. May I please report? I'm Shirley Ayers, and I represent the appellant R.W., who's the mother of A.W. A.W. was sheltered by the Department of Children and Families on December 18, 2004, along with her other 3 siblings, and the allegations were primarily hazardous conditions in the home. The trial judge continued that shelter hearing to allow the parents to be represented by attorneys and to also continue to clean their home, making it ready for the children's return.
Sarah, let me ask you a question. With
Certainly.
respect to your first point on appeal, the issue of the state not, or the court not complying with the 30-day time limit or the appropriate time limits, and the record is clear that that didn't happen. My question to you is that it appears that there's at least 2 other districts that have considered that, whether that's an absolute bar or whether it is just sort of a guideline, and they basically said, since we're more interested in the welfare of the child than the rights of the parents, that it's not a jurisdictional bar, it's not a speedy trial period, you don't just get off, you don't get the dependency dismissed.
How do I respond?
How do you counter the logic of those cases?
Well, my argument, Your Honor, is not a speedy trial issue. We didn't even have a petition or a complaint. They failed to file a dependency petition. So my argument, in essence, is a speedy filing argument. Those other cases that you allude to, the other districts, yes, have decided that there shouldn't be a bar. The case should not be dismissed if the trial does not occur within the 30-day time period. However, I compare what happened in this case to criminal procedure. You can certainly obtain jurisdiction over a defendant once he's arrested. However, if there is no charging document ever filed or trial, then the case is dismissed. So you lose jurisdiction over the defendant.
Well, but
the legislative intent, if I may, Your Honor, continue. The legislative intent under State v. Osborne indicates, well, the argument under State v. Osborne is that you should look to the legislative intent to see whether or not making a particular statute mandatory would defeat the purpose of the statute. Chapter 39 is for the protection of dependent children. It is also concerned about quick permanency resolutions for the children. If a dependency petition is not filed, as in this case, one was not filed until 13 months after the child was sheltered. 13 months after. And the child remained out of home in foster care, where she was abused twice. She was sexually molested and burned in 1 foster care placement. Filing a dependency petition places the parents on notice of specific allegations as to child abuse, neglect, or abandonment. They are on notice as to what specific allegations the state has against them. They are also able then to challenge whatever evidence the state may have. When you don't file a dependency petition, you're not made aware of what the specific allegations are. I know in this case, and I'm sure my learned colleague will say, that the parents were given a case plan. They were given a case plan, certainly, and the goal was reunification. However, the department was under the impression that A.W. had been adjudicated dependent. A.W. had not been born when her siblings previously were adjudicated dependent. She was not born. She was removed from her parents' home based on hazardous conditions. What were the hazardous conditions? Hundreds of roaches, garbage or food rotting on the counter. However, as I started to say, on December 18th, she was removed. On December 21st, the department came back in front of the trial judge and told them that the parents had substantially improved the conditions of the home, but that they were now concerned about the mother's mental illness. Based on that information, the fact that there was a history of domestic violence or some domestic violence that had occurred prior to December 18th, and the fact that the mother seemed to have mental health issues, the court decided to keep A.W. in shelter. My, again, argument is that the court does not or is not able to exercise its dispositional powers until the child is found to be dependent. The court then can require the parents to participate in treatment. They can also decide permanency options for the minor child.
But in this case, though, I just want to make sure I understand the facts.
Sure.
The child's removed under a shelter order. 12 or 13 months goes by, and everybody's kind of rocking along, oblivious to the fact that there's been no dependency petition filed. The state then files the dependency petition, and the court adjudicates the child dependent. So I understand your second issue about, the evidence, but as far as the first issue goes, your complaint, as I understand it, is the lack of a timely filing of the petition for dependency to deprive the court of jurisdiction.
If it's not mandatory, again, if we're wanting quick permanency resolutions for children who are in out-of-home placement, certainly now that the child has been adjudicated dependent, the parents are required under Chapter 39 to be given a case plan and are to be given enough time to comply.
Well, I agree that this isn't the model of efficiency that we would expect.
That's correct.
From either the court, the parents, or the department. However,
if it were mandatory, Your Honor,
the case law that I looked at the MT case out of this court and the DD case out of the 4th District, and they both seem to oppose the position that you're advocating.
And I guess it's because I'm not doing a very good job of making a distinction. I think if you were to have a speedy trial and rule, and there was one in juvenile dependency, it would defeat the purpose if you were to dismiss based on lack of jurisdiction if the case is not brought to trial, because it's likely then that here the allegations will be so remote in time that you wouldn't be able to refile based on any present circumstances. I think that would defeat the purpose. Certainly there are occasions when you continue because you don't have essential witnesses or parties. You may not have the evidence before you, so there's a need to continue. But if you don't have what I consider to be a charging document, a petition at all, then you cannot even go forward to trial.
Well, but if your client felt that her child had been unlawfully removed, and she had court-appointed counsel.
Yes, she did, Your Honor. In fact, before me, I think she had 4 attorneys.
I mean, a habeas petition could have been filed.
And I cite that, too, in my brief, as you read. A writ of habeas corpus could have been filed.
So, again, This may be one of those points where we have to agree to disagree.
Disagree. But the legal remedy, too, for the department, I know that learned counsel argues, well, you know, what do you want us to do, return the child? No. You could request an extension of time for an extension of time. You certainly, if the conditions remain the same as when the child was removed, file another shelter petition and or do a direct filing of a dependency petition. But it certainly, again, is a violation of due process of my client, and also her fundamental right to parent her child was violated. For 13 months, her child remained in foster care placement.
Wasn't she incarcerated for some or all of that portion of time?
No, she was not.
I thought at the time of the hearing she was incarcerated.
She was incarcerated at the time of the hearing, but not at the shelter, Your Honor.
No, but I'm talking about, I mean, at least up to the point of the hearing. I don't know how long she'd been incarcerated.
I think a month or two before that.
And certainly she wouldn't have been capable of parenting.
Which is why she requested that the father be reunited with the child. And I make that point in my brief as well.
Okay.
And on my second point, again, I do believe that the allegations were too remote in time. There wasn't present harm to A.W. In fact, on December 18th, the department itself had indicated that the home was substantially improved from December 5th. But the findings of fact that are in the trial court's order focuses primarily on events that occurred on December 5th and December 6th. No one had even been out to the parent's home after December 18th. I tried to certainly find out whether or not there had been any efforts to reunite this family or to even see whether the conditions had been remedied. The initial hazardous conditions had been remedied to the extent that the child could return home to her father. The only statement or argument made by the counsel for the department is that he was not living at home. He was living on a horse farm because there was a foal about to be born. But that has nothing to do with whether or not he could perhaps get a babysitter or be able to take care of the child. The child had been returned home. Now, in the cases that I provided to the court, specifically W.T. versus the department and B.C. also versus the department, W.T. is 787-924, and B.C. Versus the Department of Children and Families is 846-1273. They both focus on remoteness in time. In fact, there is even a definition of prospective abuse and imminent abuse, as I make mention in my brief and argument too. The allegations of neglect are just too remote in time. There's no nexus between any hazardous conditions. There were no expert testimony at trial, so there were no witnesses there to actually testify as to a nexus between any hazardous conditions and harm to the child. Again, however, the findings were based on what occurred on December 5th and December 6th, not what had occurred since that time, especially on December 18th. There was also no identifiable illness. There was no testimony at trial of any identifiable illness or behavior or conduct that would prevent the parents from being reunited. So there was no evidence or testimony of any prospective abuse or imminent abuse.
What about the finding that the trial court makes in the order that with the exception of the child at issue here and a 17-year-old that had already been adjudicated dependent, 4 other children born to these parents had been permanently removed, 3 by TPRs and 1 by a voluntary adoption.
I think
Isn't that a pretty relevant factor?
I think so. I think you still have to look at the current conditions. We don't know that we don't know for one thing, I don't know the reason that those children, those parents' rights were terminated to those children. It may have nothing to do with any behavior, present behavior, or current behavior. Again, I think that's too remote in time to make that a factor or a relevant factor in terms of adjudicating AW dependent. The court did not specifically address the reasons for the parent's termination of parental rights or the adjudication of the other children. But again, I believe the adjudication was in 1998, and at the time of that adjudication, I don't know that AW was even born. Thank you.
Thank you very much.
You have about 5 minutes left for the vote.
Good morning. May it please the Court, I'm Ralph McMurphy for the Department of Children and Families. And also here today is Mr. Young from the Guardian Ad Litem program. And if the Court has any questions for Mr. Young, I'll be happy to cede some of my time to him. But first, the Department recognizes that this was not the best way to handle filing a dependency petition. But under these circumstances where the other siblings had already been adjudicated dependent, and everybody, including the court, failed to pick up on the fact that a new dependency petition regarding the new child who had been born after the prior adjudication of dependency hadn't been filed. But nobody brought it up until the adjudicatory hearing. And the Department believes that it's not jurisdictional because this case was proceeding toward permanency whether or not there had been a petition for dependency filed. There was a case plan in effect, and the Department had already reached the point of going to proceed toward termination of parental rights when it was discovered that, hey, we forgot to go back and add her to the dependency petition, or to amend the dependency petition to include her. But that mistake on everybody's part should not be used to penalize the child.
How do you respond to her second point, which is there was no evidence presented of a present risk to the child?
Your Honor, I think that under the MF case from the Supreme Court, we presented ample evidence of a present risk to this child because there was a long history of domestic violence in this home. If you go back and look at the original dependency order, which I believe is found beginning at page 193 in the record, the children were found, the older siblings were found dependent in 1998 because of domestic violence and also because of filthy conditions in the home and alcohol or drug problems. You come to the 2004. Those conditions were still the same. And the parents in this case were given a case plan to try to correct those, which the general magistrate had recommended to the trial court be determined that they were not in compliance with their case plan, and The court proved that. So they were still in the same condition at the date of the adjudicatory hearing as they had been in 1998 with domestic violence. And
What was the evidence that there was domestic violence as of the time of the hearing?
There was none, because if it's as of the time of the hearing, the mother was incarcerated.
So what's the basis of your statement that the court had evidence that they were in the same condition in 2006 as they had been back in the 90s?
Because they had not done anything to address the problem.
Was there evidence at that hearing that they had not done anything to address the problem?
There was evidence throughout the proceedings leading up to the hearing that they had not complied with their case plan, which included addressing domestic violence. And because of the finding that they had not complied with their case plan, that's what made the department start looking toward termination of parental rights.
Do you agree that the department had an obligation to prove a current risk at the time of the dependency hearing?
No, I do not.
What is your position as to what the department had to prove at the time of the dependency hearing?
The department had to prove that if either the child had been neglected or abused in the past.
Any point in the past? And could you bring a case about a 12-year-old child and present evidence that he'd been abused when he was 2?
No.
Okay. So what time frame do you have to establish the abuse for?
Well, this child had been neglected or abused in 2004, the end of 2004, when she was taken into custody. Nothing had been done to improve the situation meaningfully in the 13 months in between, and under the MF case, the court is required to look at the totality of the circumstances to determine whether there is risk to the present child, meaning the
current risk, or there was a risk at some point in the past?
It would be current risk, because that's what you're looking at. If these children are returned, or if a child is returned to the parent, would that child be at imminent risk without judicial intervention? And in this situation, the court's finding that the child would be, because there had been a pattern of domestic violence, there had been a pattern of their prior involuntary terminations. Going back to 1998, the same problems continued in 2004, and then nothing had been done to address those.
Would the pattern of involuntary terminations be enough by itself? Could the department simply have come in and proven that all their other kids have been taken away from them, and that's enough to establish that there ought to be dependency on this kid?
No, because I think that that would be relevant.
Be one of the factors in looking at the totality of the circumstances.
And that's what the Supreme Court said. If you look at the totality of the circumstances, past history, what's intervened, what has been done to change the situation, to correct the problem. And in this case, nothing has been done.
And what was the evidence that nothing had been done? Because they weren't in compliance with their case plan?
Yes, because they had, it showed that this is not something that, it's going on at least since 1998, where they've been living in filthy, hazardous conditions. There's been domestic violence, and
Was part of their case plan to, in essence, have a clean environment for the kids?
in the current case plan, yes.
And was there evidence that they had failed to comply with that provision of their case plan?
I'm not sure.
Was there any evidence that they still had filthy conditions at their home as of the time of the hearing?
Not that I'm aware of, because I don't think that,
Was part of their case plan to deal with domestic violence issues?
yes.
What kind of plans? Attend courses, stay out of trouble, those
Yes.
kind of things?
And,
Was there evidence that they had failed to comply with those portions of their case plan?
yes.
What had they failed to do in that regard?
Well, I believe you can go back to the General Magistrate's report, which was in early of 2006, and it details what had not been done and what still needed to be done. And that report was approved by the trial court. Thank you.
Any rebuttal? All right. Thank you.
Thank you all.
Court will be in recess.